Council versus GN and another.
The court has made an anonymity order in relation to the claimants in this case, so no one must publish or reveal any information which would be likely to lead to their identification or that of any member of their families in connection with these proceedings. The principal question which arises in the appeal is whether, and if so, in what circumstances, a local authority owes children a duty of care under the common law to exercise its statutory powers so as to protect them from harm, or alternatively, whether, and if so in what circumstances, such a duty of care is owed to children by the social workers in the local authority's employment. The facts of the case have not been established, and the claim has been considered on the assumption that all the allegations made by the claimants are true. The question is whether, even making that assumption, the particulars of claim should be struck out as disclosing no recognizable cause of action. It is alleged that when the claimants were children, aged 9 and 7, they and their mother were housed by the defendant counsel next to a family who persistently engaged in antisocial behaviour. The claimants and their mother became the target of harassment and abuse at the hands of this family for more than 5 years, until they were rehoused. As a result, the claimants suffered physical and psychological harm, for which they seek to have the council held liable in damages. One of the claimants had been identified by the council as a child in need, as defined in the Children Act of 1989, as he was severely disabled. The other claimant was also identified as a child in need during the period when the family suffered harassment, after he ran away from home, leaving a suicide note. As a result, both claimants had social workers allocated to them during the period in question. The claimants bring their claim against the council on the basis that it owed them a common law duty of care to exercise powers which it possessed under the Children Act, under which it could have removed them from their home. The claim was initially struck out on the basis that no relevant duty of care was owed to the claimants, but their appeal against that decision was allowed by the High Court. A further appeal by the council was then allowed by the Court of Appeal. The claimants now appeal to the Supreme Court. The Supreme Court unanimously dismisses the appeal, holding that the claimants' particulars of claim do not disclose any recognizable basis for a cause of action. The claimants accept that the Children Act does not give them a statutory cause of action. In other words, when Parliament enacted the legislation, it did not confer a right of action on persons who were affected by a failure by local authorities or social workers to perform the functions given to them by the Act. So the question is whether the council or its social workers nevertheless owe such persons a duty of care under the common law in relation to the performance of their functions under the Act. Public authorities do not owe a duty of care at common law merely because they have statutory functions, even if by performing those functions they could prevent a person from suffering harm. However, they may come under a common law duty to protect someone from harm in circumstances where the general principles of the law of negligence would impose such a duty, as, for example, where the authority has created the source of danger or has assumed a responsibility to protect the claimant from harm. In this case, the claimants contend that the council or its social workers assumed a responsibility towards them to take reasonable care in investigating and monitoring their position. It said that if such care had been taken, the council would have exercised its powers under the Children Act to remove the claimants from their home into at least temporary care. But the court is not persuaded on the facts alleged that there was, even arguably, any assumption of responsibility by either the council or its social workers. A defendant may assume responsibility to a claimant where he undertakes the performance of some task or the provision of some service for the claimant, with an undertaking that reasonable care will be taken. Such an undertaking may be express, but is more commonly implied, usually where it's reasonably foreseeable that the claimant will rely on the defendant to take such care. In the circumstances of this case, however, the claim does not set out any basis on which such an assumption of responsibility might be established. The council and its social workers did not, for example, provide any service to the claimants or their mother on which they could be expected to rely, nor could it be said that the claimants and their mother had entrusted their safety to the council or its social workers, or that the council or its social workers had accepted responsibility for their safety. Nor had the council taken the claimants into its care so as to assume a statutory responsibility for their welfare. Any uncertainty as to whether this case should be struck out is eliminated by the further difficulties that arise in relation to the contention that the council breached its duty of care by failing to remove the claimants from their home. In order to obtain a care order under the Children Act, it would have been necessary to establish that the claimants were suffering or were likely to suffer significant harm which was attributable to a lack or likely lack of reasonable parental care. But the harm suffered by the claimants in this case was not attributable to a lack of parental care, but to the conduct of a neighbouring family. There were no grounds for removing the children from their mother. The appeal is therefore dismissed.